This nation was established because the people that put it together believed that you were created equally by your God. And he put in you the desire to determine your existence in this world, okay? And they tried to craft a system, learning from the mistakes of past systems, to harness that and allow for that, because they believed that that would result they believed it was morally imperative, but they also recognized that it would result in immeasurable prosperity. And it turned out to be right.
Hey guys, this is Chaz Roberts. I'm a personal injury lawyer. It's my life's mission to bring the law to the people in an easy and direct way. And that's the purpose of this podcast. You are listening to Law Have Mercy. I am super excited about our next guest, Benny Benazesh. He's a classmate of mine, a good friend of mine. We work together. He slept on my couch 1,000 times. And interesting fact about Benny, I think he studied for the bar for 2 weeks and passed it. Yeah. But he is a criminal defense lawyer, and we're going to learn a lot about criminal defense today. What's up, B?
Actually, I used Chaz's materials, so it saved me $1,500, and I passed the bar first try. So
I hope the time limit has run for them to come after you for that.
It's all good thing.
Why do you do criminal defense, right? So
Yes.
Why should the average person care about criminal defense? They're not all criminals, right?
No, most people will go their whole lives without ever having to deal with a criminal prosecution, okay? At least here in America and certainly in Louisiana. But I think when we live our lives and we generally live within the law, we expect we're exempt from any prosecution, but the reality isn't. The average person never knows when they're going to find themselves in a situation where they could be potentially facing criminal prosecution. So even if they're not actively, or if they've never experienced it, it concerns them.
Right, and so criminal defense is wide-ranging, right?
Sure.
What types of offenses, and I know it's a whole book on it's Title 14 in Louisiana, but all of the criminal charges, but what do you typically see, and what is the average type of arrest?
Oh, well, so, I mean, I've handled cases, everything from misdemeanor crimes like simple battery and domestic cases and OWI, all the way up to felony murder, second-degree murder, mandatory life. Or I'm not capital certified, okay, but the entire range. Most of what we see, you see a lot of, like in terms of felony crimes, mostly what I handle is felony crime. Most of what you see is a lot of property crimes, so thefts in excess of $500 and then on up, burglaries. You also do see a lot of things that, like domestic battery cases, that after your first or second offense misdemeanors, or because of any number of factors contained in the allegations like strangulation, children being present, burning, use of a weapon, or second-degree battery injury, automatically elevates to a felony. So you see a lot of that kind of stuff, and then just like a lot of property crimes, theft crimes, and then interactions between people. We have more and more shootings in Lafayette all the time. Those typically result in either attempted murder charges, sometimes second-degree battery, or aggravated second-degree battery.
And you're a public defender, and you have a private practice.
I'm a private practitioner. I have my own firm. I have since basically we hung a shingle all those years ago after we got out of school. And I handle public defender cases on a contract within Lafayette Parish. They have a model where there are some full-time public defenders. Usually it's lawyers that are new to the bar, and it may be their first job. And then there are contract public defenders like me that most of them are very experienced. Actually, a lot of them are more experienced than me. And they just basically take a certain amount of the felony caseload from the public defender's office in exchange for a set monthly contract.
You've handled murder cases?
Yes.
And how does a law, I know the answer to this question because I've spent a lot of time doing criminal defense as well, but you tell me in your words, how do you represent someone that you know is guilty?
Well, okay, firstly, as a lawyer, you have to, the system is supposed to provide the presumption of innocence for my client. I first have to provide that presumption of innocence. Now, if there's overwhelming evidence of my client's guilt, what's typically better for his representation is to be honest with me and tell me what happened, okay? Because just because you kill someone does not mean you're necessarily culpable for murder, all right? Like, I tried a murder case not long after I came on with the public defender's office, where my client denied to me that he had anything to do with it. Okay, and he had I think a good reason to have something to do with it, but his whole time he denied to me that he had anything to do with it. And I tried to sort of break through. Part of the problem with the being in a public defender position with a client is that client's already had 3 or 4 lawyers maybe. Some of them have made him promises they didn't keep. No telling how many public defender lawyers he may have had on prior cases, where if he has developed a distrust for me because of I'm a provided lawyer to him, it's going to be hard for he and I to have a good working relationship. Whereas if he comes to my office and he gives me $30,000, he's going to probably listen to what I have to say, you know.
So the problem
and he'll trust me to tell me, yeah, I shot him, but this is why I don't think it's murder. Or I can tell him why I don't think it's murder. And we can figure out a defense. And maybe an absolute denial is the best defense. You don't have to say anything in a criminal trial, you know. But when you're facing an immense amount of evidence, maybe overwhelming evidence, if you don't give a juror something as an alternative explanation, then you might just sit there quietly, listen to the evidence, cross-examine, and then get convicted and sent to Angola. And when you're facing second-degree murder, if you're found guilty, judge has to send you. That's all he can do. Can't give you less. It's life without parole, you know, at least here in Louisiana.
So let's get back to it, though. If you suspect that person did a bad thing, regardless if there is an explanation or a defense, why is it important for you to defend that person?
Okay, so you know, you're not asking as a moral question. It's important to defend the innocent person as it is to defend the guilty person, because the rights of all the innocent people, whether they're ever charged with a crime or not, they are protected through the defense of the accused, whether that person is guilty or innocent. Meaning, our job is to limit the state's encroachment on our fundamental liberties. The state has an interest in prosecuting crimes, clearly. But that was, you know.
And citizens have a interest in the state prosecuting crimes because we can all be a little safer, right?
Listen, I practice criminal defense, okay? I think probably the stereotype of me is somebody that would be a sort of cop hater, if you will, right? Or anti-police. The truth of it is we all need police. When I'm done with a case, I go home to my family. By practicing criminal defense, or really just being anywhere around the criminal justice system, you will quickly learn that without some degree of criminal law enforcement, we'd have a major crime problem. Okay, and it would come home to you. One of the startling things when I started practicing law is learning how common property crimes are. So like, it's more likely a person in Lafayette Parish, okay, that to have an interaction with the criminal justice system because they were victimized by a crime than being prosecuted. That's I don't know the stats on it, but I just know that's way more likely here.
You're more likely to be a victim than be accused of a crime.
Absolutely. For people here in our parish in general, absolutely. Okay, that's where they're going to interact with police, is because they were victimized by a crime more than likely.
And that's probably the standard across the country, right?
What I'm talking about is when we start picking juries and you ask if people are victims of a crime, I'm not saying it's most people, but at least those in the jury pool, it's pretty close.
It could be a theft. It could be a theft. It could be a burglary. It could be a misappropriation of funds. It could be.
You usually
I'm sure I was a victim of some type of crime. I'm sure
somebody took your wallet in the courthouse. They couldn't prove that he consciously took it, but he had your wallet and all your money.
So I never carry cash on me. I was going to a bachelor trip right after I had to leave court, and so I put $1,000 cash in my wallet because I'm leaving for the trip immediately after court. Okay, I go through the metal detector. I put my wallet. Bad move, by the way. You shouldn't put your wallet in a metal detector. I put my wallet in the metal detector. I walk through. By the time the bucket comes to me, no wallet, no one else around.
Right.
It became a mad dash, ran to security. We found the person that took it. I go up. We find the guy after 30, 40 minutes. He still had the wallet with all the cash in it. We recovered it. Thank God.
That's right.
Asked me if he was arrested.
No.
He was not arrested.
And it almost never happens that the property gets recovered. It's part of what's wrong with how we handle crime is reactive, right? So from a victim perspective, you almost never get your stuff back, okay? if it turns up at the pawn shop, maybe. But that cash would have been gone if he gets it out the courthouse, unless he genuinely took it by mistake, realized his mistake, and brought it back.
That was the excuse.
And it maybe it was, but you know. So were you a victim of a crime? I don't know. You're trying to gauge somebody's intent, and you could never prove it, and they wouldn't waste their time with something like that because you got your money back, right?
Exactly.
But yes, for the average person, it matters because whichever end they're on, they're going to encounter it. And if they've encountered it as a victim of a property crime or something else, they may have experienced some frustration with it from that side, and rightfully so. And if they've ever been prosecuted, or if they ever are prosecuted, someone they care about is prosecuted, they're probably going to experience some frustration on that side as well, even if that person is actually guilty, you know? And so, you know, if we're talking about actual guilt, or if we're talking about legal guilt, that's not determination. It's not a determination that's made until a person's either found guilty by trier of fact or they admit guilt, you know? Until then, they're presumed innocent. It's hard to do that for people, right? It's part of the problem with the jury system is, you know, I have had a juror admit that when they saw in that murder case, my client and the other client was two defendants. When she saw them, she immediately thought they must be guilty. Okay, she knew nothing about.
Was it because they were in the orange, or they
can't?
She stereotyped.
The juror's never supposed to see someone in prison orange or stripes or something like that.
But they've been in jail.
I understand that, but what I mean is that
no, I'm saying that I get it. You can go get them a suit, but they've been in jail, right? You're gonna look a certain way after you've been in jail, and you can't take care of yourself the same way.
Yeah, for people that know, there is a big difference there. You can slap a suit on somebody, but they've been locked up for 3 years. There's no way to put on their best face. Okay, it's not possible. And you know, probably even more than a person's physical appearance, it's the psychological strain of being incarcerated pending trial that weighs on them and affects them more than anything else when they're actually at trial.
Right.
Okay. And you can bond out for murder, but typically second-degree murder in life of parish, $250,000 bond. So you got to have $30,000.
So you have to have 10% or 12% of the total amount.
You're supposed to have 12.5%
cash to bring to a bondsman. The bondsman puts literally up a bond. Or can't you also have some type of property bond?
So if you have the full amount of cash, you can post it all, and the sheriff holds it. And when your case is done, regardless of the outcome of your case, as long as you come to court and conclude your case, your bond money is returned in the end. Okay, it can also be applied to fine and stuff like that. That almost never happens.
A bond or bail is a tool used to make sure the person goes back to court.
Right, and it's types and forms of bail is what the law says the state can impose to secure your appearance at trial. And then what happens is they'll set a bail amount, let's say $10,000 on a low felony. And then for a person that doesn't have $10,000 to be able to get out, or doesn't have $10,000 of property in Louisiana they're willing to pledge, they have to go to a commercial bondsman. They give them 12.5% or whatever they agree to, and then they write the bond through an underwriter. They keep a small margin, and then if you don't come to court, they kind of try to get you.
And that money's gone forever.
Gone forever.
The cash is gone. So someone gets accused of a crime, they have to come up with pay a bondsman. Mm-hmm. Then they have to turn around and hire a private lawyer.
They don't have to because
of the public defender. But if they wanted to hire a private lawyer, then they would have to come up with that cash too.
That's right. And different lawyers charge different ways, but commonly in a criminal defense practice, what you're going to have is a base retainer amount that you're going to pay as a flat fee. Okay. And that's typically going to be at minimum $5,000 on a felony, okay? And then every lawyer is going to structure their contract differently, but usually there'll be additional costs that obviously, if there's like expert witnesses or things like that, you can have provisions for trial deposit and things. But basically, just to get the lawyer on the case, to enroll, to examine the evidence, to do negotiations with the state, and kind of set out what the trial defense would be. That's what you're looking at. To actually go to trial, and that's a low-level felony. On a murder, it's going to be a lot more than that, right? Because the lawyer already knows that it's going to be extensively more evidence, okay? And then that's all if it gets resolved without the need for a trial. Almost all the vast majority of criminal cases do get resolved without the need for a trial, okay? Because the state will offer something, or the defense will propose something, and it just sort of gets worked out, all right? And it's in everybody's interest in a way to do it because there's not enough resources to try every single case. In fact, the jury pool does not want to have to come to court to try every single case as prosecuting in Lafayette Parish. Like, people would have to commit to a lot of jury duty, you know? And so the alternative is what happens now, which is a lot of plea negotiations. There's a lot of people that if they're eligible, they're placed on probation, give them a chance.
Plea agreement, plea bargains, bargains. And that's where the state recognizes that it may not be a slam dunk, or we don't want to devote the resources to this, so they'll come to some agreement that the state, the prosecutor, and the defense lawyer or the accused agree to, which would be less of the maximum potentially that they could face if they were convicted.
All sorts of ways that pleas can be structured. It can be an amendment of the charge a lot of times. Okay,
a reduction. They reduce the charge from
could go from a felon to a misdemeanor.
From an aggravated battery to a simple battery, right?
Or even sometimes going from like aggravated to second degree can open up sentencing opportunities that didn't exist with the original charge, right? So like the classic one is in murder is trying to negotiate a manslaughter, right? And sometimes you do that because it probably fits because that may be all the state can prove, right? And other times you do it because the state may be worried they can't prove the case at all, but the client is worried that if he gets convicted, he's going up for life. And so if they're willing to make him an offer on something that, say, has a cap, instead of a 40-year manslaughter sentence, maybe they agree to a particular cap, and then he knows he has a maximum of 25 or 30 years, and he takes his chances with the judge and goes and presents his mitigating evidence, rather than risking a jury of his peers, some of whom may think he's guilty as soon as they see him, from deciding whether he spends the rest of his life in prison. So, and sometimes even innocent people that are actually innocent may opt to take a plea out of their best interest rather than going into the inherent risk of a trial. For example, imagine being accused of being sexually inappropriate with a child. It's so young. It's almost impossible to know what actually happened or to really effectively cross-examine a child. Okay, like a 4-year-old child where the accusation is it's 6 months stale before it's questioned.
But even the accusation,
it's a horrible thing. But what I mean is you're looking at 25 to life.
Right.
And if you get convicted, they got to give you 25 to life. But then they say, hey, we know it's maybe you didn't do it. And you're like, I didn't do it. Okay. Well, we know maybe you did. So we're going to offer you an opportunity to not have to go to trial and not go to jail. Well, what do? Because you'd like to think I'd go in there and say I'm innocent and I'd present my case, but what actually happens is you go in there, a jury gets selected, of which you have some control over, but not entire control, and then the state makes their case against you. And then you get to ask questions of the state's witnesses, and you get to present evidence after they're done of things that may undermine the evidence they present or somehow show alternative evidence that shows that you're, not guilty. In a case like that, you don't have that evidence. You don't have physical. It's an absence of evidence that you're relying on for a jury to say this is not enough to convict this person and send him to jail.
And you have limited resources.
Right? Even aside from that, in a case like that, what evidence exists? What do you have to prove conclusively your innocence? You don't have any, and there is none. You may very well be innocent. You can get up there and say that you are. You may have people that can come out and say, I've known this person his whole life. There's no way he could have done it. You may be able to present people that say that the opportunity for the crime did not exist the way that it was described. But what you're asking is a jury of people, many of whom have their own kids or have had kids or love somebody's kids, and they see this kid saying, this man did this to me. And you might look exactly what they think a pedophile looks like. Okay, and so if you happen to look like what they think a pedophile looks like, and they show up and they think, oh, that dude looks like a pedophile, and then a little girl comes in and says, he touched me inappropriately on my booty and tootie, then you get 25 to life, is what I'm telling you. And that's all it takes in some instances, because you're relying on a group of people to make a decision, and we are so inherently biased and so unaware of our biases, it's inherently risky. And we'd like to think that, people are good enough and smart enough and honest enough that they will do their best. And I think generally jurors do, okay? But we all come into it sort of with an expectation about crime and punishment that makes it hard for us to believe somebody is at a trial and yet they're innocent, right? And
there's been some studies done about juries where it's a group think, that's problem, right? there's a group think, like if you even have a conviction that this guy is innocent, when you're staring at
11 other people
that feel a certain way, it's hard for the average person to stand up and fight for what they believe is right? And there's also, they're away from their family, they're away from work. Mm-hmm. They don't want to go in deliberations 2, 3, 4, 5 days, right? The state has brought to death innocent men. We know that.
Yes. DNA exonerated a bunch of people that were serving life, or were still facing their death penalty.
Or that have already
been executed.
Been executed.
Right. Yeah.
Right.
That's right.
That's what the Innocence Project is about.
That's correct.
So
we know it is possible to convict innocent people. It has happened many, many times.
I believe you have a quote. I mean, it's a flawed system. It's not a perfect system, but it's a pretty damn good system.
It's better than it was before. I mean, once upon a time, you basically could get hauled up without any sort of protections, and the police function wasn't limited in their interactions with you. They could take an accusation, go get you, bring it in front of a magistrate, or work for the king, and they decide what happened. And that was it. And there wasn't any way to appeal it or anything else, basically. And a lot of times they decide, execute you right then and there, right? That's why they sort of fought the revolution, and they came up with this complex system that places the ultimate power for the decision of guilt or innocence, at least in major cases, with citizens, right? So the judge is there, and the judge presides. But the judge can't convict you in a murder case in Louisiana.
The judge is the referee.
Right. The judge is supposed to make sure that everything kind of stays within bounds of the law for the purpose of the trial, so that at the end of the trial, the conclusion is upheld under law. Because basically, if things get too far out of bounds, if the state gets too far out of bounds, or even if the defense gets too far out of bounds of what's allowed through the rules of evidence and other things, it's all a waste of time. It's going to get overturned and sent back. You got to do it over again, regardless of what the result was. You see? So judges have a very particular interest in trying to keep their record of a trial proper and clean, so that when it gets reviewed, because in a murder case, it's going to get reviewed. A person's going to, if they're convicted, they're going to be in jail for life. And if they're acquitted, the state is going to feel like a murderer went free. They're going to oppose it and appeal it. And so, trying to not allow things to be so sloppy in a way that they get undone is, I think, probably the judge's primary concern in the case.
And that would be a waste of resources if it has to be retried.
It would be totally.
The staircase trial.
That's right. Now, the judge also has a lot of decisions that he makes in terms of evidence before it gets to the jury. Like, he is that referee of what is allowed. And so if the judge makes a mistake somewhere in there and disallows something that should have been, or allows something in that should have never gotten in, that can result in it being overturned. So and it's embarrassing for a judge. They don't want to do that. They want to try to properly administer justice within the rules. It's not always clear. Novel things come up. It's why we have case law, because as much as you may try to create a perfect way to apply a set of standards to any particular fact pattern, time and history and case law proves there's almost always some kind of exceptions that come up. Some of them are valid,
So it's, help me out here. Do you see the whole criminal justice system as a scale where you have the state pushing one way and criminal defense lawyers pushing the other way, right? And you're trying to find the balance for a society where the defense lawyers are pushing back to preserve the constitutional freedoms the constitutional rights. And the constitutional rights, not only the 4th Amendment and 14th Amendment, which talk about illegal searches, illegal seizures, but the right to a trial by jury, a right to
confront your accuser,
cross-examine,
compel people to come.
Compel.
It's a search
5th
for
Amendment,
truth, right?
Not to
have to
self-incriminate yourself, right? All those constitutional amendments is almost all about criminal defense law, but it extends to other areas of society, right?
The scale is justice. The other side is liberty. Right? So all those things you're describing, those are things designed to protect liberty. The basis of our society is our freedom as individuals, our free will. Like this nation was established because the people that put it together believe that you were created equally by your God. And he put in you the desire to determine your existence in this world, okay? And they tried to craft a system, learning from the mistakes of past systems, to harness that and allow for that, because they believed that would result they believed it was morally imperative, but they also recognized that it would result in immeasurable prosperity. And it turned out to be right, okay? The problem, though, is when we start placing things on the scale where it's not so much a pure sense of justice, but more like security, right? Like we confuse justice and security, right? Because people want justice when they feel like they've experienced an injustice in their life. But until that happens to them, what they really want is security. They want to be safe, and that has tended to be what we've given up in a way over time by just sort of ceding more and more authority to the state at all levels to deal with society's problems.
And if you get to the point where you give up those rights, it's a tyranny. It becomes
potentially. Tyranny. I mean, those things were placed to protect against tyranny, right? The tyranny of the state against the individual, right? So that's the point I always try to make about your earlier question. Is the reason why somebody who has nothing to do with criminal law or criminal activity should care about how criminals are prosecuted is because those rights are their rights, right? So the rights of the individual that's being prosecuted and the outcomes from that and where our law sort of moves over time applies to everybody, even if they've never been in a courtroom. And then if the circumstances change where they, for some reason, are being prosecuted, they're going to find out that what they maybe thought they had as far as protections, they don't actually have. And, look, I think it's all still very much operating in good faith here, right? Police, by and large, go out and they try to do an extremely difficult job under terrible circumstances, and they largely do the best they can. They see everything that we see, okay, plus a lot more that never gets charged or brought up to that level, and they experience it on the street when it's still hot. You see, we get it cooled off on paper, okay? And so, and it can be demanding on a person psychologically, even in a courtroom, when you're handling 30 felonies on a docket, okay? It's why public defenders burn out, right? It's why these young attorneys that come into it have such a hard time, because they've got, hundreds of files, and these clients all have a major stake in their case, and you've got one lawyer trying to kind of figure out how to do this on 300 cases all at once.
Spinning plates.
And lawyers that have practiced for 30 years, they still analyze every single case individually, because it's how you have to do it. And then you have to figure out what the law is as it applies to this case and see where you can work the case.
And every case is unique and all presents its own defenses and strategies and facts and
that's right,
personalities.
The case probably, I don't want to undersell lawyers. And the reality is, there are really good lawyers out there, and hiring a particular lawyer may make a major difference in the outcome of your case. But I think most experienced lawyers will acknowledge that what matters more than the lawyer is the facts. The lawyer has to work within what the facts are, and ultimately that's determined at trial, but what the evidence tends to indicate the facts are. And, it's supposed to be that sort of search for truth, determination of facts. The reality is there's a lot of gray in there, and there's a lot of messiness to it as a system, just because it's all people and people are all imperfect. From what I described to the jury, to the individual lawyers, to everybody has their own interests that they take into this, And even if their heart's in the right place and they're doing it for all the right reasons, they're not going to get the exact right outcome all the time. You know what I mean? I've sat with somebody that I think did commit the murder, and at the end of it, I still felt like, when he was convicted and sentenced, I still felt like it wasn't justice, because the guy that he was convicted of killing had shot his own brother, my client's brother, weeks before, or a few months before, in a drive-by shooting, shot him like 7 times. Guy miraculously survived, but the shooter in that case was released from jail within like 3 months. So he's back out on the street. So it's like there's a whole bunch of mess there that it's not black and white all the time like you maybe imagine it is, or you think it should be. And I think some
especially when you take the time to get to know the individual.
That's right. That's right.
And so even on black and white, that doesn't tell the full story, because you took the time to understand how it came from and how it originated, and you probably saw it as street justice, right?
Well, murder's wrong. Okay?
Murder's wrong.
And I think morally murder's wrong, and cultures all over the world acknowledge that, okay? But we acknowledge within the law that there's sometimes you can shoot people. I've represented 3 people arrested for murder, okay? And we participated in the grand jury, which is typically a big no-no.
One-sided.
You typically don't do it. It's conventional wisdom for defense attorneys. You don't go testify at trial, and you don't go participate in a grand jury, because a grand jury only sees the state's evidence. Mm-hmm. You don't get to present a defense.
And a grand jury's the purpose of the grand jury is to determine whether there's enough evidence to bring formal charges.
That's right. So most of the offenses that the state charges, they do by bill of information. But when something carries life in prison, they have to go to a grand jury, which meets in private, secret, gets the evidence presented to them totally by the state.
It's a jury of citizens, right?
That's right. It's the same process for a jury pool and stuff. You just don't go through the trial voir dire where the defense gets input on who gets selected.
Yeah.
And you don't get to question any of the evidence. You don't participate in that way. If you're invited to participate, and if you participate, you only go in to be questioned, and then you leave. You're not there for anything else. Lawyer can't even speak in there other than to quietly advise their client. I don't make any presentation at all to a grand jury. But there's 3 different people that I've represented that shot and killed someone. And we talked about the risks and potential rewards of participating in the grand jury process based on the facts as they appeared in their case. And in all 3 of them, there was a no true bill found by the grand jury, which means the grand jury said this was not murder, someone died, but this was a justifiable homicide. It's not a murder in violation of our law. And as a result of that, those people were able to not have to post a $250,000 bond. They sat in jail for about a month, you know. They did not have to face a murder charge. They did not have to go hire for trial a lawyer to defend a murder charge. And those cases almost all certainly would have been plea down type cases where they would have got some kind of offer. But they still would have had the charges. If the grand jury comes back with a murder charge, the state has a murder charge against them, they're going to prosecute them. They're going to initiate that prosecution. They're going to make a determination from there.
So for the defense lawyers listening to this, you don't recommend
it's not
participating in the grand jury.
It's definitely
it's not a blanket.
That's not
wisdom. That's just like a southpaw move.
Not what they teach you in law school, right? Because you have nothing to gain. Right? Because anything you say in front of the grand jury can be used against you at trial. However, I think sometimes when the truth is in your favor, if you have some faith in those people, and my point to my clients is always that imagine this process where these people are in a meeting in the DA's office on the 6th floor of the courthouse in a conference room where they're just being presented evidence of your guilt.
Yeah.
What do you think they're going to say? Okay, charge him. They're not even on the hook for what happens to the case.
You have nothing to lose.
It's easy for the juror to say, okay, charge him because y'all will figure it out in court. And then if he's innocent, he'll get acquitted.
Yeah, but he's stuck in jail for 3 years until he gets a trial
People
date.
aren't aware of the realities of facing that system bearing down on you. And that's what some of my clients have been aware of. And they know if I can take a chance now to say what I'm ultimately going to say if questioned by the jury, which I already told the police, which is the truth, I'm going to go in there and speak the truth. And hopefully they believe me. And by doing that, what happens is you humanize the client so that they're not just some person on a page who's responsible for a death. They're a human being that came in here and looked you in the eyes, and you got to ask them questions. And if they convinced you, that they were in reasonable apprehension of an imminent injury from that other person, and they only used a gun in their defense, and they believe you, that's not a crime. And why wait for a jury trial for that? You see? Because at the grand jury, if you lose, guess what? You get a murder charge, which you're going to get anyway.
Murder charge.
If you're convicted at trial on the murder charge, guess what? You're in Angola for life, okay? Yeah. Short of somebody deciding on appeal, which is a slim, slim chance that something was wrong, So, and that's not a decision for me as a lawyer. It's not the way I look at it. Client hires me. I work for the client. I tell them what I think and why. They make the decision,
All right, Benny, let me give you an example. All right, so you go out to dinner with your wife. You have a couple drinks. Nothing crazy, right? And you go out to dinner, and on your way home, you see the blue lights behind you. What do you do?
Right, so this goes to your earlier question where somebody who may not commonly encounter police, a lot of people that are charged with OWI have never had any criminal history. I see people 50 years old, never been arrested, pick up an OWI.
And OWI means operating while intoxicated.
Operating while intoxicated is the Louisiana statute, and it's called DUI, DWI, different states, but it's all basically the same thing. So what's going to happen if an officer pulls you over and suspects you've been drinking, whether he developed that suspicion before he pulled you over or after, he's going to start asking you some questions. And so what you should not do is admit to drinking, having been drinking. You don't have to tell him where you've come from. You should be courteous and respectful. But if he continues to persist and he asks you to do field sobriety, that's a test to determine whether he has probable cause to get you to blow. You should not do field sobriety. And then if he takes you in, you should not blow. Okay? So don't admit to drinking. Don't admit to the traffic violation. You don't have to say where you're coming from. Don't do field sobriety, and don't blow. All if you've been drinking. And the reason why, I'm sorry.
Well, I was going to ask you, you're probably going to get arrested at that point.
Yeah, so if he has articulable suspicion to cause you to have to do those things and then you refuse, he's going to arrest you. And there's a mechanism to have an enhanced penalty for your license suspension if you refuse to submit to the breath test. It's the implied consent law.
So the bad news is if you refuse to cooperate, right, even though you're being respectful and courteous, you're probably going to get arrested and you're probably going to get your license suspended.
Correct. And
that's the con.
And they're going to use those things, those threats of those things, to induce you to get to do the other things that are actually going to give them the evidence of your guilt, at which time you're still going to get arrested and still you lose your license.
So the cop is going to be telling you about the consequences. Hey, look, if you don't do this, I'm going to arrest you. If you don't blow, you're going to get your license suspended. They're going to be telling you. And a lot of people initially, from my experience, I've handled over 1,000 of these, initially refuse. And then as the cop starts talking to them, they oblige, right?
That's right.
They think that by cooperating, they're somehow going to have some type of chance to get out of it.
That's right. And so what happens is it's an interesting little dance. The officer is not telling you that you're going to be arrested, so he doesn't have to Mirandize you because he hasn't made that determination yet.
And Mirandize is what?
Where you see it on the cop shows, they have to tell you have a right to remain silent. You have a right to an attorney if you can't afford one. One will be provided for you. Okay, so that's a case called Arizona or U.S. v. Miranda. I think it was at Arizona. Basically, it says that the officers have to advise you of your constitutional rights before they question you when you're suspected of a crime, because your confession can then be drawn and used as your guilt. And so you have to be advised of your rights before you confess to a crime.
And how many hundreds of cases have you experienced? Because I know I've had my share where they said, dude, I'm good. They never Mirandized me, right?
Right. It's a common misunderstanding or misconception. You don't have to be Mirandized to be arrested. And oftentimes you're not, because they only need to Mirandize you if they intend to question you. So like in the case of an OWI, if he does his complete his investigation on the roadside and then he determines that he's going to arrest you, but he doesn't Mirandize you, as long as he doesn't question you any further after, it's still okay. You'd only have the ability to suppress statements made post-arrest if they failed to Mirandize you. Doesn't even mean the charges necessarily go away. It'll depend on what the remaining evidence is.
So if you follow your advice, you don't make any incriminating statements by saying that I was drinking. The famous quote that I know is, I've had two beers.
Everybody
has 2 beers.
I said 2 beers.
How many? I mean, I can't tell you how many times I've had 2 beers, because people think that if they're honest to some extent and just admit to something, because obviously the cop knows because they can smell it and see it. If they just admit to 2 beers, that's low enough on the poll where the cop would say, he was honest. Have a good day, son. But
people are so wanting to avoid the taken out of their car and get arrested that they try to talk their way out of it.
It never works.
It's what you said is, if you know that you've been drinking, and I blame some of that misconception. When I went to driver's ed, they taught us 1 beer per hour. Doesn't matter how many beers. As long as you only drink 1 an hour,
your body will be able to process it and you won't actually
the legal limit, okay?
Right.
Well, the legal limit, commonly known as 0.08, is not really the legal limit. At 0.05, you lose your constitutional presumption of innocence. Between 0.05 and 0.08, there's no presumption either way.
Which is very little.
And over .08, that's a statutory definition that you are presumed impaired. It's almost over. You can't overcome it unless you could indicate for some reason that there was a problem with the number or the timing of such that it didn't reflect what happened when you were driving.
That's why I asked about going to dinner where you have 2 or 3 glasses of wine over an hour period versus, look, if you've been at the bar and you've taken shots, if you've had multiple drinks, you're going to be over the limit. No questions asked. I'm more nuanced about a couple glasses of wine.
You see those though. If you blow over your OWI, if you've gone to dinner at the same place every week for 50 years and you've had your 2 glasses of wine and you've driven home and you've never been stopped and you've never had an accident, you may have violated the OWI law every single time you've ever done that and never been encountered. And then you get encountered and you feel like, I'm perfectly safe to drive. I'm going to be honest. I'm going to do these tests, okay? The tests are designed to allow the officer to determine there's a probability that you're going to blow at 0.1 or greater. That's how they've designed the test. If they are performed in a standardized fashion, they should result in a consistent, predictable probability of 0.1 or greater. It's what allows them to then go bring you in to make you blow. They don't have you blow on the side of the road. They bring you in, even if you're not technically under arrest at that point.
Well, I've been doing this for 13 years. I don't handle OWIs anymore, but I've handled over 1,000 of them. And I've just been in the public and people have called me, just as a lawyer, common question.
What to do?
I don't know of a single case, and I'll ask Woody this too. I don't know of a single case where someone was brought to the station, took the test, and they said, "Oh, you're under the legal limit. Go home. Have a nice day."
Never seen it. I've actually seen them blow under 0.05, but they charge it because they presume that it's a combination of drugs and alcohol at that point. Okay, even if the prior testing on the field did not indicate drug use,
they still got you.
They're going to find a way. And so the point is that if you are around the possible, the first thing I say is they taught us wrong. You can't drink an hour and still drive. If at any point during the night you felt the effects of alcohol, even mild effects, the flush, the first things you feel when you feel the effects of alcohol, you can't drive that night.
Well, the other thing is we were drinking, it's 1 5-ounce glass of wine, a shot, or a beer. Mm-hmm. I don't know about you, but when we were drinking Natty Lights back in college, it's not the same as the beer nowadays.
16-ounce Natty Ice with like a 12% alcohol content. It's not a 10-ounce Michelob Ultra, so is a beer?
But it's not the craft beers.
No, that's right. It's not
either.
A stout. That's right. Yeah. So it's just a poor way to look at it. And you, again, there's lots of people that I think probably drove responsibly under what they were taught, what they thought was the law, drinking moderately, and drove safely for many years and didn't realize maybe even that they were in violation of the law until they get stopped and they find out they are.
Which is why the advice that you're giving is so critical and so good, because there's so many factors. The best advice is don't cooperate, right? Because you can't not make that determination on the side of the road.
If you know you haven't had any drinks at all, then sure. What I'll tell you is that doesn't mean you still won't fail some of the field sobriety. The field sobriety is not that easy to do. And if you're in a nerve-wracking situation, you're not listening very, very closely to the instructions, you're going to make some mistakes simply because you're not executing it properly. It may have nothing to do with your impairment or your balance. Those are still cues used to develop the probable cause to bring.
But the reality is, if the police officer is asking you to do that,
you're going to jail.
You probably
are over.
Or have had something in your system, because I've been stopped by the cops when I'm, obviously wasn't drinking or anything else. And we really didn't talk about a field sobriety test or a breath test.
Right.
We talked about why I was going 10 miles over the speed limit.
It's the first thing you should do is always be courteous to the officer, because I think a lot of times the officer will pull people over, maybe with an inclination there could be something going on, and they quickly resolve that it's not what they thought. And they may even just let you off on whatever the traffic violation was with a warning, because I've had that exact same thing happen many times. Okay, I've also had some situations where I was basically suspected of operating, and I didn't follow my own advice that I'm giving here because I knew I had not been drinking at all. And after some time, I was let go. And if they'd have made me blow, I would have blown 0 because it wasn't impaired, And so But yeah, the smell of alcohol is always the reason whether it exists or not. And if it exists and he legitimately smells alcohol on you, you're probably over, because you can drink so little and not be over. And so it's a difference between being able to safely drive and being able to drive safe from prosecution for OWI.
Let's shift gears. Having a party at our house. Got a lot of people over at the house. There's a noise complaint or something, and the police officer knocks on the door. He asks to help himself inside. What do you do?
Well, he should ask, and he's asking because he can't just help himself inside. The home is different, okay? The home, you have the highest level of protection against the police intrusion. And so if he simply knocks on the door because of a noise complaint, he's got a reason to be there, and he can ask you to turn the noise down, but doesn't give him a reason to come in the house unless there's something else going on. So you can politely deal with him, decline him coming in your house, and turn your music down. You know, and if there's no reason to not let him in, you could let him in. I mean, it's just that if there may be some other reason to not let him in, if he were to come in with permission and find evidence of any other crime, he can then use that crime to arrest you, because you will have granted him access to your home, where he would otherwise need to apply for a warrant and have to demonstrate probable cause before getting the warrant signed.
So the same question. You open the door. There's a huge cloud of marijuana smoke coming out the house. Can he then enter the home?
So it's like yes and no. Okay, because physically, sure, he can go in there. And I've seen where they have done that before, okay? And they will attempt to create an exception to the Fourth Amendment based on that articulable suspicion, okay? Like it's an exigency. If we don't go get that right now.
Okay, we're using big lawyer words. What are those?
So like
what does that mean?
One of the things I was saying earlier about how people don't realize how many exceptions there are to the Fourth Amendment. You think a cop cannot come in your house without a warrant. But there's a lot of ways a cop can come in your house without a warrant, okay? And so an exigency is a circumstance where if the police can demonstrate that something was so time sensitive, like a crime in progress situation, where if they don't go and secure it before being able to get a warrant to seize it, that it will be lost forever.
Is that a domestic situation in the back? Is that seeing needles on the countertop? Like what is?
Okay, so seeing the needles on the countertop is different because that's a plain view exception. So another exception to the Fourth Amendment. If an officer is in a place where he has every reason to be and he's not in violation of anyone's constitutional protections, and he observes in plain view a crime or evidence of a crime, he can get that, and it's admissible. You see, he doesn't need a warrant for it because he discovered it in the natural process of going about whatever he was investigating, right? If it's hidden and he can't see it, even if he knows it's there, if you don't give him permission to go into your home to get it, he's supposed to have to get a warrant, okay?
So can you lock the door and talk to the cop through the window, or walk around the house and talk to him outside?
I've seen actually a lot of videos where people kind of have odd exchanges like with officers, and largely the officers sort of respect the threshold, okay? So if somebody wants to talk to them through a screen door or a window next to a door, I mean, if their purpose in being there is to try to talk to somebody to turn the music down, or they're investigating domestic complaint or whatever, then that may be enough, you know? And if the officer at that point doesn't have any kind of reason to give why he has to go in the house and you don't let him, he can't really get in, you know? But they don't, you know, we don't live in a place where the police kind of go randomly knocking on doors most of the time. They get called to places, and so they have a reason to be there, and they have the authority to investigate the call, at least to make sure there's no crime happening right now.
And they can use their eyes, nose, and ears once they're there to see if there's any issues going on that could potentially give them the right to enter the home based on one of those exceptions, plain view, some type of other crime within that they have an idea that's going on, or whatever.
And I think the traffic stop is a tougher situation because the officer is already on guard at a traffic stop, because it's a much more risky proposition. If they're going into a house, they know the house is dangerous, they're going to get everything lined up and go in right. They're not just going to go knock on the door, right? But in a traffic stop, it's always just sort of a knock on the door. It's so random. You never know what they're going to walk up on. So it's just edgy from that perspective. Whereas a normal interaction at a home, if it's in that kind of circumstance, should be much more sort of relaxed from the officer perspective. So it should be easier for the person, knowing they're much more protected in their home, even if they're hiding something from the officer, to sort of remain calm and courteous and relaxed, you know.
What about combining of the two worlds? You're about a block away from your house, you see the blue lights come up behind you, and you turn into your driveway, get out the car, go into your house before the officer gets out of his car or approaches you.
That's a novel situation. I would be willing to bet there's some examples of that. I'd have to double check on, but I would think that if the cop is pulling you over simply because of a traffic violation, he's hard pressed to follow you into your home. But I also think a lot of officers would be inclined to do it in that moment, and then it would have to sort of be sorted out after the fact as to what was the offense. Like, that's pretty extreme if somebody just ran a stop sign to chase them into their house to go arrest them, because you can't even arrest them for the stop sign. Now, if it's ag flight, okay, so like in Louisiana, I don't think you should ever run from the police, and I think you should cooperate with the police insofar as you should be respectful to them, and you should engage them in conversation if they're needing to ask you questions. That doesn't mean that you have to incriminate yourself, and if at some point it's obvious that they are interrogating you or the investigation is turning towards interrogation, you can actively invoke your right to remain silent and your right to attorney. And just say that, I want to remain silent until I have an attorney present if I'm suspected of a crime. And at that point, it should be completely shut down. They shouldn't ask you any more questions, because anything they get after that, it should never be admissible, okay?
So you recommend someone say, I want to be silent and I want an attorney. The Sixth Amendment is actually stronger than the Fifth Amendment in terms of shutting down the conversation.
Automatically, that's right.
And you see that on all the crime shows, right? Sometimes they'll remain silent, and I think the officers have a chance to try to start talking to them again, right, and elicit information. But when they say, I want my attorney, that's right, it's over. They cannot talk to that person again until they speak to their attorney.
That's correct. And they've weakened the right to remain silent, because now you actively have to you have to invoke it. Right. You can't just remain silent. Right. Okay. You have to invoke your right to remain silent.
What would that sound like?
I guess if you had a card on you that said, I invoke my right to remain silent, you wouldn't have to speak, but otherwise you basically have to speak, right? So it's kind of counterintuitive, you know? But basically, you know, in my personal experience and in my experience as a professional, most of your common interactions between police, if you engage them with courtesy and you show them sort of the respect of their authority and you answer their questions that are not incriminating to you, it shouldn't be a problem. If you're actively committing a crime and they know you are, then you need to basically lawyer up, remain silent, go with the process. Don't give them access to anything to search that there's incriminating evidence. Don't admit to doing anything. Don't lie, because a lie, if provable, is indication of guilt. You're much better off just saying, I want to remain silent until I have an attorney. And I've seen people do it where officers basically have to walk away because they don't have enough yet. You know, when you invoke your right to remain silent and you ask for your attorney, you have to be decisive in it. You said they cut it off immediately. Sixth Amendment right to counsel present for any kind of interrogation. But you can't say, I think I need an attorney, or I might need an attorney. You can't ask the officer, well, do I need an attorney? You see, that's not conclusive. You say, I want an attorney. I need an attorney.
And after they say, I want an attorney, and they say, I want Benny Benazesh, where can they find you?
It's a little hard to find me, but I'm in the All Center. I'm at 322 Hyman Boulevard in the ASPA building. They can also call my office. You can find my number. If nothing else, you can call my guy Chaz, and he'll send you over.
I'll put you in the show notes, man. I'll put your contact in the show notes. Okay. All right, man. Benny, thank you for being here. It was a fascinating conversation. Thanks a lot, buddy.
I appreciate it, Chaz. I enjoyed it. Thank you.
All right, man. I hope you enjoyed the podcast. None of the opinions of the guests reflect that of my own, and nothing in this podcast is to be considered legal advice or create an attorney-client relationship. This is for entertainment purposes only. Thank you for watching and listening. Hope you enjoyed.